Let's get some legal analysis on the case now. Joining us is Hofstra law professor James Sample. Professor Sample, thank you for the time this afternoon. Prosecutors presented emails, documents, phone records. In your opinion, as you followed this trial, was there a smoking gun in this case, or was it sort of the cumulative effect of all the evidence?
Jessica, it's good to be with you, and I think that the answer is that it was definitely the latter. There were over 1,000 evidentiary exhibits presented over the course of the 2-month trial here, and as Alice's report just indicated, the jurors really deserve an extraordinary amount of credit. When you think about giving up, in essence, 9 weeks during the summer, no less, of your life and your autonomy to listen and to not be able to speak with each other about the case, the one thing that you have in common, until you get to deliberate. They did an extraordinarily thorough job. This was a complex case because it involved multi-pronged conspiracies. It's true, and one of the things that the defense tried to make a significant factor, particularly in its closing arguments, is that there's not one smoking gun, but the prosecution countered that with a very, very compelling story that just because there's not one so-called smoking gun, the cumulative effect of all of that evidence, all of the interactions, and the very, very compelling, I mean, if you're going to do bribery, you might as well go big, right? Go gold bars, go Mercedes-Benz, go $480,000 in cash sewn into your pant pockets and hidden in your closets. The defense tried to point the finger at Nadine Menendez, but remember, we're talking about the third-ranking official, at least at the time that the charges were initially brought, on the Democratic Party side in the United States Senate. So arguing that he's a somewhat clueless dupe who had been, fooled by his girlfriend and now wife was not a particularly compelling argument, although it seemed to be all the defense really had.
Right. No, I think that's a fair assessment. The former senator decided not to take the stand in his own defense, which is a defendant's right, but sometimes it can affect the outcome. Do you think it affected the case?
Well, it's hard to know whether it affected the case. I think that certainly had Senator Menendez taken the stand, he would have opened himself up to a host of other charges, perjury being foremost among them. I mean, we saw this New York, the Southern District of New York, and earlier this summer in the state courts of New York, not far across the way there downtown in Manhattan. We saw with former President Trump. The risks for most defendants, particularly in white-collar cases where the facts are complex and where the questions can come at you blindly, far outweigh the rewards for most defendants in these kinds of cases. I think they made a sound decision. It's easy to Monday morning quarterback, but from a lawyering standpoint, putting Bob Menendez on the stand would have been extraordinarily risky. I think one of the things that is especially compelling about this case, and I think it offers a kind of teachable moment. In 2017, Senator Menendez faced another corruption trial. That case ended in a hung jury. Hung jury meaning not an acquittal, but effectively, because it was never retried, effectively he got away with it, so to speak. There were jurors in that case who would have voted for a conviction. It was 10-2. Instead of being chastened by that experience, that's a 2017 case. It's 2018, just mere months later, when the fact pattern at issue in this case starts to develop. That is an astounding indication that rather than being chastened, the lack of consequences for earlier actions other than the consequence of having to endure a trial, certainly, he decided to double down.
Right. It almost seemed like he was a bit emboldened, if I'm hearing you right. So Nadine Menendez is being tried separately. As you said, Menendez's defense really tried to pin a lot of this on her. Just a few hours ago, her trial was postponed indefinitely. That was obviously before this verdict came down. What do you make of that?
The timing was certainly an eyebrow raiser. I mean, I don't know, other than the fact that she's being treated for cancer. Right. We don't know a whole lot about the precise details, nor should we really know the precise details of her treatments and diagnoses. It was odd timing that that order would come down while the jury was deliberating in Senator Menendez's case. However, I think that the safe assumption, it's not as though it's been dismissed, it's been postponed indefinitely. I think the safe assumption here is that the judge is taking some time, offering her some time to deal with the pressing matter of her cancer treatment, and we'll be on a kind of wait and see there. It is odd that that postponement occurred while the jury was deliberating, but I don't think we want to read too much into it at this point.
Yeah, interesting timing. All right, Professor James Sample, thank you so much for your expertise. I know it's a busy afternoon. Really appreciate having you with us.